Hi, everyone. Thank you for joining today's webinar presentation, Winning at 112, The Language of Patents. I'm Allie Morton, the Product Marketing Manager at LexisNexis IP, and I was just going to cover a couple things before we get started here today. Please feel free to submit questions at any time during the conference by using the Q&A feature in the panel. You can also access files pertaining to today's webinar in the handout section of the same panel. And a link to the recording will be sent out in the next day or so after this with some additional information. Now I would like to introduce today's presenters. First, we have Jean Quinn. Jean is the founder of IPWatchdog.com, a patent attorney, law professor, and leading commentator on patent law and innovation policy. Jean was recently named one of the world's leading IP strategists by IAM magazine. We also have Jennifer Bailey joining us today, and Jennifer is a partner at Arise IP, where she specializes in post-grant review of patents and patent prosecution in the electrical, computer software, and electromechanical arts. She also has experience as the president of the Association of Intellectual Property Firms, as an adjunct professor of patent law, and was named as a rising star in intellectual property by Super Lawyers 6 years in a row. In rounding out our panel today, we have Dave Stitzel. Dave is an IP solutions consultant with LexisNexis IP. Prior to this role, Dave obtained extensive experience as a patent attorney with various intellectual property law firms and as a chemical and biotechnology patent examiner with the USPTO. In addition to his roles in the patent world, he has experience as a research molecular geneticist and a research chemist in organic and polymer chemistry. Dave is registered to practice before the USPTO and is a member of the North Carolina and Pennsylvania bars. Thank you again, everyone, for attending today's presentation. And with that, I will turn it over to you, Gene.
Thanks, Allie, and thank you all for being here and spending a portion of your day with us for this webinar series. I see some of you are already asking where the PowerPoint slides are. We're going to get those uploaded into the handout section for you. You'll all get a copy of them sent to you afterwards. The reason we started the presentation just a couple minutes late was I was trying to make a few last minute tweaks to the PowerPoint presentation to make sure that we were characterizing everything exactly right, particularly when we get to talk about Williamson versus Citrix and means plus function. Want to make sure that we're getting it precise. Because things are potentially about to change, and we have some ideas of what your best practices ought to be today and for long term that we want to talk about. So let's pause here for a second. This is the agenda. You all seen this. This is the text from the registration page, so you don't necessarily need to reread it, but this is a good opportunity for me to bring in the panelists. And Jennifer, we'll start with you. I'd like to get your preliminary thoughts on 112 and winning at 112, if there is such a thing. I think there is such a thing, but what do you think about when you're dealing with 112 issues? And maybe better, what do you think about when you're trying to avoid them in the first place when you're preparing an application?
So that's a good question, Gene, and I think it starts with the Williamson v. Citrix case that we're going to talk about later. But with the proposed legislation on the table, what I think about them now may change here shortly. You know, I've been doing this a few years, and you realize that in patent law, the pendulum swings, and we attorneys have to be willing to change as the Federal Circuit and the Supreme Court change the law for us. With respect to 112F, it's important to know how best to claim draft. And that seems kind of obvious, but we tend to get stuck in our ways of drafting claims when we first learned, whether that be 5 years ago or almost 20 years ago. And with the advent of Williamson v. Citrix, we've got to change the way we draft. The patent office is putting out the 112F rejections or notifications. And if you don't know what triggers them, that's kind of the point of this conversation today. Being able to identify and being able to draft based on the particular technology, whether it's a software, whether it's an apparatus, because we're not going to draft those claims the same if we're trying to incorporate some type of functional claiming.
Yeah, I think that's right. And 112 should be scaring people, and particularly 112F. And if you have never had 112F issues before, you really, I think, need to pay attention, because you might be quite surprised. More to come on that comment. But Dave, I want to bring you in. I know you're the guy in charge of dealing with Patent Optimizer for LexisNexis, and you know, this is going to come across like it's a commercial when I say it, but I really think that attorneys today have got to use Patent Optimizer, and the reason is the examiners are obviously using some algorithm, some software, because we're getting office actions that will have 8, 10, 12 pages of 112 rejections. And examiners don't have that kind of time to dissect a specification. They don't even read the specification, for God's sake. We know that. They tell us that. So if they're using software, we need to be using software. So I guess I teed you up a little bit there, but what is your approach or thoughts about 112?
Yeah, no, and I appreciate that, Gene. And I would say that, you know, if you do get an office action with that many 112 rejections, you know, obviously that's going to delay prosecution, you know, lead to a lot of other issues, you know, including increasing prosecution costs. But, you know, the silver lining of that is that you've got an examiner that at least, you know, had the time and the opportunity to put that on the record and give you a chance to overcome those. The problem oftentimes comes in where examiners are, you know, tremendously busy trying to get their counts, you know, and the problem can arise where at the end of the day, if they miss them and you don't address them on your own during prosecution, you may not have a patent that's worth the paper it's written on due to 112 related errors and deficiencies. So, you know, if you go up in a PGR, obviously you're going to run up against those as well. But, you know, my thoughts about 112, obviously 112 first, second, and sixth paragraph are A, B, and F, pre or post AIA. But, you know, as you mentioned before, Patent Optimizer, it's an amazing tool. I wish I had access to this back in the day when I was examining as well as prosecuting, and it can, in fact, help you avoid those common pitfalls and unnecessary rejections. So, you know, we're going to help you, you know, confirm whether or not you have sufficient written description. We're going to also help you identify patent profanity within your claims, meaning claim terms that may be construed as vague and indefinite, functional, impacting claim breadth and scope, invoking public relations concerns, or considered offensive. And then last but not least, which is the focus of a chunk of our discussion today, is 112F. And obviously, if you have any functional claim language, means for language within your claims, obviously you need to have structural support within your spec. We identify that functional claim language, means plus function claim language within your claims. And then we also have an amazing thesaurus that can identify structural variants from the entire US, WIPO, European, and Canadian patent corpus that can help or basically be incorporated within your spec to accomplish that claimed functional language. Appreciate it. Yeah. Thank you.
No problem. Thanks, Dave. So now, those of you who have been on previous webinars know that now it usually turn to the panelists and we go through some slides and discuss. We've got an awful lot of slides here, and I want to get to as many of these as I can. So I'm going to take the moderator's prerogative here and try and push through the first few slides and bring in the panelists as necessary for commentary. And then when we get to talking about 112F specifically, then we'll turn it over to the panel specifically. But there's some things I want to lay the foundation on here. And the first thing here is the common problems. Now, we probably all know what the typical rejections relating to 112 are. They're, you know, failing to comply with the written description requirement, improper claiming, vague claiming, and functional claiming where you don't have adequate disclosure for what you're claiming in the specification, or inadequate corresponding structure. The disadvantages is where I want to focus, because as David was just mentioning, you increase your pendency of prosecution, it increases the costs, and it creates a prosecution history estoppel, because when you're having to overcome these 112 rejections that are really unnecessary, because they can all be caught if you're using some kind of software to help you catch them, that you don't have to make those corrections or statements. And then that prosecution history estoppel, and anything you do say can and will be used against you, remember, of course, can lead to weaker patents if you're inartfully are arguing these things and you get argumentative with examiners. So now, from the examiner's perspective, this is what examiners have told me. They really would prefer us to do a better job at proofreading the specifications, because they find this to be an enormous waste of time, because in a lot of art units, examiners don't have a lot of time. So if you're, and you probably know this, but let me just, just put a punctuation point on it. If the examiner is dealing with something that might be the type of kitchen gadget that you would see on QVC, they're likely going to have about 12 to 13 hours for the entire case, maybe 14 hours. If it's something that NASA is going to shoot into space on that level with, software and satellites and that kind of telecommunication stuff, very high tech, they're probably going to have 35 hours, 30 to 35 hours. So they're going to have an inadequate amount of time to really do the job to begin with. So if you're forcing them to do all kinds of work on 112, then you're going to guarantee you're going to have to file at least one RCE. Now, you're probably going to need one RCE in a lot of art units anyway, but you're just guaranteeing that the prosecution is going to be longer. So this is the reality of it. So LexisNexis does have Patent Optimizer. Now, it can allow you to check your claims, it can allow you to check your drawings for support, and it can allow you to check your specifications to make sure that everything's in tune. Now, when we get to the end of the webinar, we'll talk a little bit more about this, but I want to just mention this here because some of the stuff we're going to be talking about that you really need to be doing in part of best practices is going to sound like, how am I possibly going to be able to do that with the client budget that I have? Well, there is help. There's help out there that you can actually get. And I think we need to be leveraging these automated systems, because it's clear to me that the patent office is using some automated solutions for 112. Now, I was just I host monthly breakfast meetings in DC with a bunch of politicos in town and high profile attorneys in the know. And this issue just came up and everybody says the same thing. They're getting the same 112 rejections that you are, 10, 12 pages long. And, everybody knows without really that confirmation that the patent office is using algorithms. I mean, they have to. So you need to be using the solutions that you have as well. Whenever I do these 112 webinars, I always like to point out the 112 starts with Nautilus, and they did away with the insolubly ambiguous standard of the Federal Circuit back in 2014. But don't forget, the Patent Office does not follow that, because Nautilus was a litigation, and the Patent Office position is, since it was a litigation, it does not deal with obtaining patents, and they still follow the Packard standard. And this came up in Ex parte McWard, and which was made presidential. And they believe, because the Supreme Court has said, and the Federal Circuit has said, that the Patent Office can have stricter requirements to obtain a patent in the first place. So they follow something that looks an awful lot like insolubly ambiguous. It's the last sentence here. Put differently, claims are required to be cast in clear as opposed to ambiguous, vague, indefinite terms. So I always like to mention that because when the people get this for the first time and they see that the office is not following Nautilus, that can be surprising to some. So that brings us up to 112, the statute. And this is what we're gonna spend our time talking about: A, B, and F primarily. And now we're gonna focus on means plus function. Jen, I want to bring you in because I know you've done a number of presentations on means plus function. I know you and I have done a couple webinars on drafting where this has come up, and you had some suggestions on language that we tweak on this slide in particular. So when you're looking at means plus function, and this talks about it historically, and then we get into Williamson at the bottom of the slide. Where are we now and how have things changed?
So there used to be a strong presumption that if the claim did not recite means for performing a function, in other words, if the word means was not in the claim, then the claim was not interpreted as a means plus function claim under 112F. Williamson v. Citrix changed that and got rid of the strong presumption. Now there is only a presumption that if means is not in the claim, that it is not intended under 112F. But that presumption is rebuttable, and in our case, during prosecution, rebuttable by the Patent Office. And the Federal Circuit in Williamson went one step further and said, look, if you are going to replace means with a nonce word, some generic black box term such as module or assembly or device, those really just mean the same thing as means. So if you're going to say a device for performing some function, really you're just reciting means plus function. So what happens is we patent attorneys have gotten so used to the fact that as long as we don't have means in our claim, we're good. It's not interpreted under means plus function. Williamson changes that. And this case has been out for 4 years. So it's gone through some guidelines by the Patent Office. There's, I believe, 2 different sets of guidelines by the Patent Office. I always like reading their guidelines, by the way. They're always very helpful. And most, I would think, practitioners at this point, say that again, Gene.
I said the guidance is always interesting to read and helpful, even if you don't like what it says.
Well, that's true. Hey, you have to know how to work with the Patent Office and the examiners in their training. So
Right.
Work with what you have. So the big takeaway from Williamson is we can't just not use means. We've got to stop using these nonce words. And what happens is, for example, if we have a recording device for recording, well, is that a nonce word? And so then the question becomes, under the Williamson analysis, if the skilled person would understand what that word you used to explain the function had a special meaning within the art, okay, well then it's not a means plus function. Or if they would be able to look in the specification and understand that it has a particular structure, not a means plus function. If you're reciting that structure, that recording device, and it includes additional structure such as a memory, it's not going to be interpreted as means plus function. So there are easy ways to not draft a means plus function. The problem is we're so enamored with this functional claiming that I'm going to use the word generic and abstract because it kind of gets to what we're going to talk about later, that we forget to add in the necessary structure, even if it's just minimal structure. And so we're ending up with 112F problems that we're going to have to address both in the Patent Office and sometimes in litigation.
Yeah, I'm gonna kind of, well, I guess we could just go to the next slide here, because we're gonna have some slides that flush out what Jen just said. But here's a list of some non-structural terms that may invoke means plus function, and you know, I guess this is not particularly surprising, and we're gonna, I don't even know what to say. I mean, things are, you're gonna understand why I'm stuttering and can't figure out what to say when we get to talking about the proposed legislation here. But Dave, Patent Optimizer does have a tool that allows you to check to make sure you're not using language that would be potentially interpreted as means, correct?
Yeah, that's right, Gene. We do look obviously for means plus function language, and we'll call that out in our check claims feature. And then you can toggle through the spec to make sure that you've provided structural support for accomplishing that claimed functional language. But we also do look for some of these nonce terminology as well, mechanism for, module for, so on and so forth. The reason why we don't look just for, mechanism alone without being in combination with for is that you could probably appreciate and imagine that we would get a lot of, false positives. And as we know from cases in the MPEP, that sometimes prefixes, prior to the mechanism may be enough to provide that structural support. If it would be, readily interpreted by one of ordinary skill in the art, as to know what the structure is for accomplishing that mechanism with the prefix information. But yeah, the answer is yes, we do look for that.
Okay. So this is, I put this together, the good, the bad, the ugly. I personally don't find it at all problematic to use means claiming as long as you do it with eyes wide open and you know what you're doing. Because how many of us have ever had a situation where a client has said, draft every possible claim that you can to cover the invention? I know I've never had that, and I think I know only one attorney who's ever had that once in his career. So means is going to cover the full extent of your disclosure. So having one or two of them in the application, I think makes just good sense. Now, if you're going to have too many of them in there, that's going to be problematic. So I think proper use of means claiming is all good. Overuse of means claiming is bad. I think, and that's why in the bad, I say means plus function should be used like seasoning, a very powerful garlic. A little bit is going to go a very, very long way. And then the ugly is the algorithm cases where if you're going to use means plus function claiming in software, you have to disclose 100% of the algorithm. And Jen, that's scary. I mean, the NOAA systems case, that's we got a slide coming up on that. We'll get more into that later. Let's lay the foundation so everybody knows what we're talking about when we're talking about Williamson versus Citrix. Do you want to take this, Jen?
Sure. So as we were saying earlier, there's a rebuttable presumption now, not a strong rebuttable presumption. So if you don't use means, it's presumed to not be a means plus function. That can be rebutted by the patent office. And so those are the 112F interpretations that you're receiving in your office actions. Again, using nonce words is going to contribute. We've already discussed the patent office has a list of those words. So anytime you're going to start using them, module, system, even assembly sometimes, a mechanism, you're teeing yourself up for the means plus function interpretation. One thing, and I believe we may have a slide that addresses this. I am a firm believer that especially younger examiners are going to put out all of the rejections that they just learned and are going to put out the 112F just so that they cover their bases. And the examiners are now being trained on 112F to put it in there even if they don't truly believe that it's an issue, because they want to make the record clear. That's the whole point of the prosecution process. So if you have a 112 interpretation and you are not happy with that, in other words, you don't want the claims to be interpreted under 112F, you need to address it. You need to talk about it. If you do not do that in your responses to the office actions, those claims are forever going to be construed under 112F. And sometimes, I would say that most of the time, it's pretty easy to overcome and have that interpretation removed if you just explain to the examiner, here is my structure, or either in the claim, or here is why the skilled person would understand this structure to be, or this particular word to have particular structure. So make sure you're addressing them.
Yeah, we have a question here, Jen. It says, under Citrix, if a claim recites non-structural terms, so example, a device for, and there's sufficient structure in the spec, but not sufficient structure in the claim, is that okay? And the whole point of means plus function claiming is you're not going to have sufficient structure in the claim, and you're relying on the structure that is in the specification. Because if you do have sufficient structure in the claim, it is not supposed to be interpreted as a means plus function claim. I got that right, Jen, right?
That is correct. And so a way to deal with this, and we have a slide that addresses this later too, but a way to deal with means plus function, kind of have your cake and eat it too, is to use a more generic term. Let's just say a controller. I want to use a controller, and this controller is going to perform some function. But now I'm going to add to this controller that it is associated with or in communication with a memory. I have now added the structure of a memory to the claim limitation. That is a sufficient amount of structure to remove it from a means plus function interpretation, because the good thing from Williamson is that the Federal Circuit made clear that if you have even minimal structure, actual structure attached to this not term, that removes it and overcomes the presumption that it is a means plus function term. So think about what structure you can put into the claim that's really kind of meaningless for infringement purposes. In other words, any infringer is going to have this particular structure. It does not have to be there necessarily for patentability, in other words, to overcome prior art. That's one way to address it. But if you simply have a nonce word without any structure in there, even if you have sufficient structure explained or described in the specification, you're still liable to be interpreted under means plus function and limited to that structure that's disclosed in the specification. And here's something that maybe is not completely, we're not being completely clear about. There's two issues that arise with means plus function. One, if it's a means plus function term, you then turn to the specification to see what the corresponding structure is, and that is the limitation of your claim. But a problem arises if you do not have sufficient structure disclosing it. Not only do you not have any corresponding structure disclosed in the specification, but now you have claimed yourself into a written description problem where you don't have the support for your claim element. And so that's why Gene keeps on talking about how we have to have these detailed specifications.
Yeah, a detailed specification cures all problems. You know, and you know, I've had arguments with some patent litigators at times, and they say you cannot read into the claims, and that's simply false. You absolutely can read into the claims from your specification. The rule actually says you cannot impermissibly read into the claims. There are all kinds of times you read into the claims. Means plus function is just one of them. I mean, so if you're using means for or any other language that under Williamson would provoke means treatment under 112F, you absolutely are reading into the claim from the spec. That's the whole reason to use it. It's also the reason why you want to, in many cases, try and avoid it, because you're going to be limited by this, what you put into the specification. But don't forget, when when it says you're impermissibly reading into the claims, what is permissible is defining. And the examiners, if we go back to the slide, I don't know, let me see if I can find it quickly. They like having definitions in the specification. So what you do is we have this big complicated term or concept, you define it in the specification, and then you just use the label in the claim, and that label acts as a hook. This is how I always teach it when I'm teaching new attorneys. You have that hook in the claim, which is the label, and it goes into the spec and pulls that concept into the claim. I mean, so there's all kinds of ways and times where you are going to read into the claims from the spec. So but that requires a good spec. And and this is why so many of the webinars we do is how do you do that given the constraints that clients place on you in terms of budget. So again, not to sound like a commercial, but I do think Patent Optimizer is a great product because that is one way. If you have access to it, you can use it for all your cases. And if your clients aren't going to pay a lot of money to do what needs to be done, you're going to be able to create quality patents within a budget, which is the way you distinguish yourself from others. Another way you distinguish yourself from others is not getting those 10, 12 pages of stupid, silly rejections. I mean, how do people explain that to clients when you get 10, 12 pages of 112 rejections before you ever get to a 101, 102, or 103? I mean, I guess if your client doesn't understand and you tell, oh, this is normal, well, it shouldn't have to be normal. You can do something about it. And I'll get off my soapbox now because what I want to do is I want to circle back, Jen, to these nonce terms. This is another thing that we keep talking about. And I get it. I understand the concept. An adjective plus nonce term, don't do it. But this is scary. I mean, how in the world is element or member a nonce term, or engine?
Well, or fiber optic transmission element. So
that was the one that caught my
selected.
attention. That's real. That exists. That is a thing. It's tangible.
Yes, these are all examples from my prosecution practice. Did everyone hear that? I have had 112F applied to every single one of these: reciprocating member, Deaton mechanism, etc.
Yeah,
now,
the two that really caught me were the fiber optic transmission element and reciprocating member. I mean, how many patent attorneys out there have used reciprocating member? I mean, if you do and I didn't do it last night. I got caught up when I was preparing and going over all these slides late last night. But I would have to think reciprocating members got to come up in thousands of patents.
Well, and then that's the prospective versus backwards look if the law changes on prior patents and we've written under a different age and how they're now going to be interpreted. Yeah, reciprocating member, very common. I think image display device is really interesting. The examiner in that particular one accepted display as not being a 112F, but because the word device showed up, it was interpreted under 112F. So we amended those claims and got rid of image display device, which I think is slightly more actually structurally significant and replaced it with display. Sometimes it is form over function with the patent office, and I think 112F and use of some of these terms is an example of that.
Yeah. Well, a lot of the folks on this call will know my my partner, John White, from Patent Bar Review fame. He probably helped many of you pass the patent bar through his course. His approach to 112 is when an examiner has an issue with language, his approach is, well, I didn't really like that language myself. Let's just get rid of it. What would you like, examiner? And tries to co-opt the examiner into cooperation and figure out what it is, because that's a great example. If they have a problem with image display device, but they don't have a problem with display, that is so form over substance. That's just weird. It is what it is, though, right?
Yes, you're right.
So
again, you need to understand the game you're playing.
Gina, I would add to that I think it's a great idea to open it up and get feedback from the examiner, but I would also come to the interview prepared because I can tell you from prior experience that oftentimes they're on a fishing expedition and they don't have any ideas of their own and they weren't well prepared. So if you go in well prepared with some of your own suggestions and then you follow up with, but if you have another alternative suggestion, I'm happy to to entertain that and pass it back to the client for their
Yeah.
analysis. I
Well,
think
see,
that goes a
that's
long
right.
way.
I mean,
Yeah.
you're right. I mean, and he does. He goes in. You have to know what's in the spec. You have to know what's in the claim, and you have to know what you can live with. But by doing it that way, by approaching prosecution in hopefully a cooperative way, you may find, and he does a lot. And this is his. We all joke with him because if you have a prosecution problem, you go to John, because we tell him he has these Jedi mind tricks, and we joke about it. He's a wizard, because by doing it that way, what winds up happening is a lot of times you wind up getting what appears to be broader claims, because the examiner has a problem with a certain word or term, but then once they say, well, I'd be okay with this term, but not that term, you look at the term they're okay with, and that's broader. And it's like, well, if you're okay with that, then sure, we can live with that. But you have to go in prepared. I mean, the preparation is absolutely essential. I couldn't agree more. So let me see. I want to see what's on this slide. Okay, yeah, this sort of sets up the Alice issue right before we get into the big scary part of the presentation. So don't go halfway. Jen, I think this comes from one of your previous presentations. A module 4 means configured to. Yeah, I mean, that just really blurs the lines and is the worst of both worlds.
I couldn't agree more. I think it's patent drafting 101 that if you truly do want to use or have a means plus function claim, it needs to be means for, and otherwise do not ever use the word means. It is on my naughty list, and if I see it in a patent application that someone has drafted for me, it will be labeled on the naughty list. But the same thing for module 4. So if you're using a simple nonce word plus the function, just be prepared that even if it gets through the patent office, you're going to face issues in litigation. And you may not necessarily want that, and it's going to detract and distract from the real issues you're going to have in litigation. No one wants to argue about 112F when you're doing claim construction and invalidity.
Right. No, well, I mean, yes and no. Oh, and I realize on this slide I've got an old link at the bottom. If you're interested, the best information for contact purposes is on the last slide. So yeah, I agree with that to some extent. Although Jen, I've talked to some patent litigators. I know you do some litigation as well, and attorneys at your firm do some litigation. And certainly you guys, I know you and others litigate at the PTAB. And certainly at the PTAB, you don't want to get into that for sure. But I've had litigators tell me that they like means plus function claims because they add a certain level of uncertainty. And from my previous litigating days, uncertainty, I know, is where settlement opportunity exists. Now, right now, that is not necessarily true because so much of this stuff is getting kicked out on motions to dismiss. But if we get past that motion to dismiss problem and we get back to a world where settlements are actually occurring, this is another reason why I would not be afraid to have one or two, purposeful means claims in an application. But again, I'm not, when I say this, I'm literally meaning one or two, because I think, and remember what I do, and maybe I shouldn't say remember, I'm assuming everybody knows me, but what I do is software, right? So who knows what claims are going to win the day? So when you're filing a software application, what you're doing is you're filing usually claims to computer readable medium. I hopefully have talked to everybody out of filing method claims, but you're filing system claims, you're filing all kinds of different claims and drafting to different kinds of parts of the invention and so forth, and you're drafting from different angles. So I like to have different claim sets and different types of claims. So I would not be afraid to have a means plus function claim in there. And if I know I'm going to do that, then I know I've got to have my specification be on steroids. And I think that is the secret for software is you have to have a specification that is capable of supporting means claims. Not that you're going to use them. Maybe you are too afraid to use them, and that's fine. I get it. The algorithm cases are really just terrible. But that's the specification you need. Jen, do you disagree with anything I said? And if so, what's your take?
I don't disagree with anything that you said. I do agree that a little bit of variance, I used to have a senior attorney at my firm say a little bit of ambiguity is not necessarily a bad thing. So I agree with that. And I agree with the detailed specification. You'll never go wrong with a detailed specification. But I do maybe just want to quickly emphasize for the group, I know we have a lot of people on the line, so we probably have a variety of levels. And you said this earlier, Jean, but to be clear, when you have claims interpreted under means plus function that are software claims, the means is the algorithm that is described in the specification. It is not the controller or the processor or the computer that is performing the function. It is the algorithm. And that's going to be really important for what we're about to talk about and what Jean was saying, because it's really, really difficult and costly and time-consuming to describe every single possible algorithm that can go along with your software invention.
Yeah. Now, and that tees up this next slide here on Alice issues. Now, Jen, back in the day, wish list claiming was, I think, why we got into this kind of problem. Now, that hasn't been allowed for some time, but if you're running into a 112F problem in the software space, that's the least of your worries, I think, because the likelihood is you're going to run into a 101 issue, right?
It is, and I've given 112F presentations before, and I've noted this. I don't think that this is original thinking on my part, but I really feel like Alice and what came about from Alice is because we got a little bit too happy functional claiming back in the late 90s and the early 2000s. And we just relied on it too much as practitioners, and the pendulum, again, it swung too wide. And the Supreme Court came back in and said, no, we're going to bring this back to center. So this functional claiming, in my opinion, gave rise to the 101 problem. And I think if you think about them, they're almost inextricably intertwined. And so that's why this potential legislation that is coming up is so scary. And Jean, I'll tee it back up to you, because it is essentially punting the 101 issue and making it a 112 issue.
That's exactly right. And this is why we've been going through and queuing up all this stuff about this is what 112 is, and this is what you need to do, and Williamson versus Citrix. And so if you're not using 112F and you're, and I see we've kept the audience, so people are interested in this topic regardless. Even if you are not using 112F claims right now, you need to expect that your claims at some point in time will be interpreted under 112F and under Williamson, because there's the current 112F and there's the proposed Coons-Tillis draft. Now, under the current law, it's expressed as means or step. Now, that was expanded, as we discussed, in Williamson. The functional claim elements under the proposed legislation would be anything expressed as a specified function. Now, if you read the proposed 112F, it reads, I think, like a fair statement, general statement at least, of what Williamson versus Citrix holds. So if what they're trying to do is codify Williamson versus Citrix, we would be no worse off. I think that would be a dumb idea. I think we should kind of pull back on Williamson rather than codify it. But I've been told that even though there's nothing been said or stated publicly that I'm aware of, at least, um, the intent is not to codify Williamson. The intent is to go further than Williamson. They want to capture more as function than even Williamson captured. Okay, so the other thing, what I can tell you here today, I haven't written this yet, but I will probably be writing this next week sometime. The 101 legislation is dead. It's not going to happen. Unless something dramatic changes, it is DOA. And the reason is 112F is a poison pill. 112F is attached to it. And what they want to do is they want to push all, as Jen was just saying, all of the 101 rejections into 112. Now, but when they want to do, by doing that, what they have the coalition that is in support of 101 reform is going to splinter, because half of them want 101 reform and they're willing to take anything and they'll fight the next battle next. Half of the people that support 101 reform, I am told, are going to oppose 101 reform if 112F reform is attached to it. And I've been told that there's no chance that 112F is going to be removed from the bill, because enough of the people, the senators in particular, enough of them that are supporting the reform would not support it without 112F, because their intent is exactly to push the rejections into 112F. Now, I think we should take it. I'm scared of it, but at least this should get us past the motion to dismiss in litigation. But whatever the case will be, is you need to know that this is gonna rear its head again, and there will be attempts to expand Williamson. Now, the other reality is whenever changes are made to benefit patent owners, they're prospective. Whenever changes are made to hurt patent owners, they're retroactive. So the 101 change, if it ever happens, is going to be prospective. The 112F change will be retroactive. So you need to know that now today when you're drafting your applications today. So this leads us to the best practices for a robust disclosure. I always talk about the first rule there, the present invention or invention. Attorneys are, if you think there's a difference between the two, or if you think we can't use the word invention in your application, you are so missing the forest for the trees. If you read the cases, Judge O'Malley has a great explanation, and I've written about it on IP Watchdog. You can find it there. I think it's the Absolute Software case that I have cited there. It says that the word invention is not limiting. Yes, the Federal Circuit has cases that suggest it is. Yes, they have cases that suggest that it's not. And she explained that the reason why the cases that say the word invention is limiting is simply because every single time the word invention was used and the invention was discussed, it had a certain feature set. So you cannot then claim it without those features. So in other words, if your invention is always disclosed with A, B, C, and D, you can never claim it was only having A, B, and C. I mean, that's just patent 101. So the caution about using the word invention is a reminder that you need to have a complete and full specification that describes as many variations and permutations as you possibly can, i.e. a non-limiting spec that describes everything. That's what you need to do. Then the next one, Jen, deals with means plus function. I mean, the word adapted to or adapted for, people think that adds structure, and that is not always the case. There's a lot of these things configured to. I mean, that every time, and I've gone through it because I'm working on a project for the class I teach about teaching new attorneys patent how to prosecute. Every time the word configured to is used in the MPEP, it's used in the context of means plus function. So if you're going to use configured to, you're going to get means plus function treatment, I think. Thoughts on that?
Kind of on that note, when we start to use this type of language, is I train my team to look at it from an infringer's point of view. How can I determine when I am infringing? Because that goes back to whether we have a definite claim, right, 112B, but it also tells me if I'm using adapted to and configured to, so that I don't know when the actual infringement occurs. And this often happens not only with structure apparatus claims, but with software claims. It's like this kind of forward claiming, like in the future, it is adapted to do this thing, or it's capable of doing this thing. Well, that's not putting any definite structure, the metes and bounds on the claim. So come at it from the infringer point of view. How would you infringe, and when in time, temporally, would that occur? And that helps you to figure out if I'm claiming too loosey-goosey, which is going to then lead up to the means plus function issue.
Yeah, and we need to do a webinar on that because that's so important. And I think sometimes people don't give that thought when you're drafting claims. It's who's your infringer, and can any one person actually infringe? And a lot of times the answer is no, particularly when you're dealing with software. And drawings are your best friend. For God's sake, file more drawings. They're cheap. They're very cheap. You get $30 a figure. Patent illustrators like to work with patent attorneys. You probably do better than $30 a figure as a patent attorney. Give $50 a sheet or something like that. Have sheet after sheet after sheet after sheet. It's going to force you, those of you who are in the audience that are younger or newer practitioners, everything that's in the drawings disclosed, and it's going to force you to spend at least a paragraph or two at a minimum describing what's in the drawings. It's a great way. And
Gene,
yep, go ahead.
Oh, sorry. Go ahead, Jennifer.
I was just quickly going to say on the drawings when it comes to software. I mean, obviously I do a lot of software and electrical, so that's my bailiwick. But if you have a flow chart where it's line to line to line and
oh my God,
pretty little set of boxes,
it's not a flow chart.
That's really not going to do it. You need to put some diamonds in there and some, have it moving around on the page.
Yeah, I like that. Give me some diamonds.
I like my diamonds.
Yeah.
Gene, I wanted to.
Yeah, go ahead, Dave.
I was just going to add to the adapted to comment. Yeah.
Yeah. Hold on. Let's, Dave. I'm going to give you the end of the webinar here to talk about some of the. So, Jen,
sure.
your last thought there, and then we'll turn to Dave.
Yeah, I was just quickly going to say, if your algorithm is A to B to C to D with no subsets in it, that is a problematic disclosure. You do not have enough of an algorithm. And so if it ever gets interpreted under the functional claiming standard, whatever it is now and whatever it may be in the future, you do not have enough detail when the algorithm is what is supporting those claims. So you need to add in the subsets, the subcombinations.
Absolutely. It's almost hurtful. It's not helpful. It hurts. A line is not a flowchart, and I say that over and over again. But I'm going to start using that. Show me some diamonds. Give me some diamonds, because that's what you need. You need the decisional points. And the way I did this with a client who had because a lot of the computer programmers they're not taught like computer engineers or electrical engineers. They don't flowchart. They just start coding. So this guy was just sort of incapable of creating a flowchart. So what I said is, look, if I can create flowcharts, can you read them and tell me what's right and what's wrong? And I kept sending him flowcharts, and he kept editing them. And as long as the ones I created were not wrong, we put them in the application to file them. We filed so many flowcharts in this application, and it was a great way to do it, so he's teaching me what the invention is as we're going over his flowcharts, and that application then wound up writing itself. It was a great way to do it. But all right, so Dave, I know we want to talk about some of these things about patent optimizer, but what is it that you had about adapted to, or
Yeah, I
it
was
deals with the language here, right?
Yeah, just real quick, I was just going to mention that, along the lines that Jennifer was mentioning earlier with associates, leveraging certain terminology. We do provide within our check terms feature the ability to access on a complementary basis patent cases where they actually construed the claim term meaning at issue, and one of those claim terms or phrases is actually adapted to, and you can see that it's been treated in the course like capable of, and so. That's a great way to leverage the tool to try to get a feel for how certain language may be interpreted if go the distance in litigation. That's it.
Okay, so what we have a few slides here that talk about some of the powers that exist for Patent Optimizer, and this is the check parts. What is check parts all about?
Yeah, so we have a lot of feature and functionality within check parts. Obviously, we're identifying situations where you have the same part number, identifying different part names. Obviously, you want to be consistent, especially if any of those part names are part of your claims. And then also the flip side of the coin will identify situations where the same part name may be identified by different part numbers. And obviously, maybe that's 100% accurate. Could be that they're just different embodiments. If that's the case, you probably want to go back and add first or second as a preface to that particular element. The other thing we'll do is we'll actually enable the user to cross-navigate from a series of terms into the drawings themselves. We'll identify whether or not certain part numbers are present within the drawings but not within the spec, and vice versa. Maybe there's a reference to a part number within the spec, but there's no corresponding part number within the drawings. And then also situations where you may refer to a specific figure within your spec, but there's no corresponding drawing of that particular figure. And then the flip side, maybe you've got a figure within your drawing set, but you do not reference that particular figure anywhere within your spec. And then one of the things, a lot of our subscribers like to leverage is the ability to auto-insert part numbers into the abstract and claims. Obviously, it's frowned upon here in the U.S. PTO, but oftentimes, that'll be sent to a foreign associate, and they're billing for that, and it's a way to kind of pad your own pockets in that billing opportunity, as opposed to that of, your foreign associate if you're going to be filing the EPO, for example. So that's pretty much check parts in a nutshell.
Yeah, I think that's a great feature because that really makes sure that everything that's in your application is accounted for in proper places. So, and then the other interesting thing that you guys have done over the last, and I think this was one of the last updates, one of the last several updates, is now you can auto create an office action response that then you can go and edit and massage, correct?
That's exactly right. And one thing I was going to mention just real quick before we get into this is that you can also generate a part name and number index in patent analytics. And that's great for prosecution in the event that the examiner is relying upon a drawing within the site of reference. We'll generate that part name and number index for you so that you're not having to go through and tease out the names and label the drawings by hand, which, I did, as well as probably a majority of the patent attorneys that practice in the mechanical and electrical arts. They're doing the same thing. But yeah, you're exactly right, Gene. We've got this new office action response shell. It's going to streamline your analysis of the office action. We're going to enable you to cross-navigate from a hierarchy of the different rejections and objections that we detect within the office action. You can click on those and actually cross-nav directly into the office action itself, so it'll streamline your analysis. It will also enable you to, draft a very robust and comprehensive shell, out of the gate. So now it's just a matter of inserting your, your substantive arguments. And the boilerplate language that we use is actually customizable. So if you've generated, a template over the years of your practice and you want to leverage some of that language, you can just modify the boilerplate that we provide. And then the last but not least, I would say that we also enable you to generate a clean claim set. So you're going to avoid non-compliant amendments in the event that you forgot to, update a status identifier or adopt a prior change claim change, whether it be a deletion or addition. So the ability to generate those clean claims, generate a very robust shell is going to be a huge time saver. And one of the things we didn't talk about earlier, but all the 112 issues that we can help you avoid, obviously that's going to decrease your efficiency, and that's very detrimental in a flat rate based billing arrangement. And then it's not uncommon for a lot of corporations to now mandate that their outside counsel leverage Patent Optimizer for all the things that we discussed earlier today.
Yeah, and LexisNexis IP has been a really awesome partner for me for a number of years, and they've also partnered with me on the patent prosecution course that I mentioned earlier. And the folks, the students who take our patent prosecution course are given access and some training by LexisNexis IP on how to use these tools, so they can learn how to leverage them into their practice. And it's fantastic. The feedback that we've gotten from everybody is wonderful. So, but I see our time, we started a few minutes late, so we've been going for just about an hour. But if you want more information, you can reach out to Morgan. But Jen, I'd like to give you, you get the final word on your thoughts about 112F. What is it that you would like people to leave remembering today?
Detail in your specification. Take the time. If you're having trouble identifying the point of novelty, and I know that seems maybe pedantic, but if you're having trouble identifying that technological solution, that point of novelty, and getting it in there and having lots of explanation on it, that is going to cause problems. It's going to cause problems for patentability over the art, and it's going to cause problems for means plus function, especially as the law continues to evolve on this subject.
Yeah, I think that's probably a good place to end, because I've always preached the specification, and people a lot of times say, well, why? Because the examiners don't even read them, but it all starts with the specification. I mean, and we're getting into it. You look at the books. Joe Root has written some books in the LexisNexis IP library on claim drafting and writing applications. And the way he puts it is, we're living in an era of the specification revolution. And if you're not on board with that, the long-term prospect of the patents you're working on today, I think, is not really great. Unfortunately, it's just getting harder and more expensive, and we need to be honest with clients. You need to have robust specifications, and that really does solve an awful lot of ills. So let's leave it there. Thank you for sticking with us a few minutes late. Sorry we started a couple minutes late. It was entirely my fault. Thank you, Jen. Thank you, David. Thank you, LexisNexis IP. Thank you, Ali, if you're still on the call with us. And hopefully we'll get to see you again at another webinar. We have a webinar coming up actually on Tuesday next week, special day, special time, and it's another LexisNexis IP company, and we're going to be looking at the Intel patent auction. So hopefully you can join us for that. That will be at 12 noon. So hopefully we'll see you then and there. But for now, have a good day.
Thanks, Gene. Thanks, Jennifer. It's been a pleasure. Bye-bye.